I was under the impression that he had the gun, and that's why I found probable cause. Not that someone else had the gun and he's just standing there. He's like standing while black.
This case isn't simple. It's packed with shock, betrayal, and suspense. The judge looks stern, the lawyers sharp, and the witness ... Is he lying or telling the truth? Don't blink, your opinion is about to change. Stay locked in.
If you cannot afford one will be appointed to you.
Watch the lawyer's strategy words like traps, and the witness is falling right in. Did you catch that flicker of fear in his eyes? This cross-examination is heating up, and something big is about to unfold. Don't go anywhere, it's just getting started.
The caller asked the defendant if he had a gun, to which the defendant stated yes, and that he had it for protection. The officer observed the group walking away from the gas station and activated his lights and sirens. The defendant began to evade upon seeing the officer. The officer had prior interactions with the defendant and knew him by sight and name. The officer later was able to locate the defendant at his residence.
So you said that he goes into a gas at Texaco.
So, Your Honor, the complainant was walking into Texaco and observed the defendant with another group of juveniles outside of the gas station with a handgun. And then
Okay, so who has the handgun?
the handgun is with the defendant. And the defendant...
He has a handgun?
Yes, the defendant said he had that for his protection.
Here's a pivotal moment. The defendant reportedly tells a random caller that he has the gun for protection. That statement could seal the deal. Or could it? Legally, hearsay isn't enough. The judge immediately asks for it to be read again, because even they feel something's off. Was it a clear admission or a misunderstanding? And what if the wrong person was identified? This is where cases fall out, get locked in tight.
The caller asked the defendant if the defendant had a gun, to which the defendant stated yes, that he had it for protection. And then the officer observed the group of juveniles walking away from the gas station and activated his lights and sirens. And the defendant...
That's when they all scam.
Yes, Your Honor.
You were on bond for 3 felony cases. I have to imagine that one of the conditions that you're on bond for is no weapons. And now you've picked up another case.
Boom. The judge finds probable cause. But don't celebrate yet. This doesn't mean guilt. It just means, legally, there's enough to continue. Think of it as the courtroom version of halftime. Still, the judge hits hard. The defendant was already out on 3 felony bonds and still picked up a new weapons case that stacks up fast. And guess what? Judges hate patterns.
I don't know military time, but 26 hours.
It's 1 in the afternoon.
1 in the afternoon, Your Honor.
So he's got the 3 felony cases upstairs. They're all no weapons as well. You need to understand that by picking up this case, it's very possible that they revoke your felony bonds and raise them. And if that happens, 3 felony warrants are going to issue for you. So
here comes the hammer. Your bonds might be revoked. That's not just courtroom talk. That's a warning shot. If those previous felonies get reactivated, the defendant could be looking at immediate lockup. It's a domino effect. This is where things get real for defendants. One slip-up can unravel everything. Let us know in the comments. Should prior felonies impact current bond decisions?
Do you understand?
Yes, sir. Yes, Your Honor.
I was appointed on this case today.
Okay.
Judge, I wanted to see if we could hear probable cause on this. I have an issue with him being arrested for this. I wanted to see if we could hear that.
Defense swings in hard. Groups don't hold guns, individuals do. Excellent point. The attorney challenges the entire arrest logic. Was this a targeted stop or just a blanket assumption? And let's face it, assumptions don't hold up. In court, this is why your defense attorney matters. They're not just fighting charges, they're fighting the method used to charge you.
And then he comes to do a further investigation. I get that in and of itself is nothing, but then they go to do a further investigation, right?
If I can make another argument, Judge, the person states that he talked to the person that has the gun, specifically talked to the one person that has the gun, and he stated, I have the gun for what,
For
my protection?
Yes, for protection.
That's him.
No.
You told me it's him.
The initial caller stated he asked the defendant if he had a gun, and then that's when the defendant stated yes, and he had it for protection. In the DMs it says the defendant.
It's not, there's 2 defendants. There's 2 people arrested. One that actually had the gun. My client doesn't have the gun. He was arrested for evading. There's no gun on him. The other gentleman was arrested for possession, I believe. A Mr. Kenneth.
This is a red flag moment. The defendant is identified through prior booking photos. Let that sink in. We're not talking about a live ID or video, just old mugshots. can a caller truly ID someone off memory like that? The law says yes, but the credibility? Questionable. You be the judge. Is that reliable or too shaky to stand on?
I asked that they look at the OR and see who actually got arrested for possessing the gun.
Judge, I think it was the co-defendant that had the gun. He's the one that was charged with unlawful possession of a firearm by a felon. This defendant,
The other co-defendant has the gun.
I believe so, but that doesn't justify this defendant running away after they established probable cause to detain him. That's the state's argument in our position for probable cause.
What was he doing wrong?
Somebody had a gun. That gives them.
Get it. So that's why that person got arrested. But
That's not.
Major twist. The co-defendant had the gun, not the client, on trial. What? That changes everything. The state argues the client still ran, which can be grounds for evading, but is it enough to prove possession? The courtroom shifts tone here because it's starting to look like this young man is paying for someone else's mistake. Or is he?
The person that had the gun, identify who
if you
that
can
person
show
was.
me something that he's doing something wrong, then okay. But I was under the impression that he did that and then he takes off, hence the evading. If he's take your time, there's no rush, right? But if he's doing something wrong, and then they're going to investigate him for doing something wrong, and he takes off, that's a different question. But if he's doing nothing wrong and just standing there, no.
And this guy that they talked to
Hold on.
admits.
I get it. Let me see if they have anything else. If not, then I'm gonna cut them loose.
Sounds good, Judge. Have a seat, please.
Okay.
Judge, so I'm going off of the OR. There's a couple of descriptions that are in here. First, there's two people that seem to be involved. One is the store clerk, and then one is the person that says he sees somebody dumping a gun. Now, we don't know what description is what, but under the point where it says prohibited weapons, suspect.
Descriptions are critical in cases like this, but here, they're murky at best. Two witnesses, unclear sources, inconsistent clothing, IDs. It's a mess. Legally, without definitive identification, arrests are shaky. The defense is pushing hard here, and the judge knows it. If they can't pin the right shirt on the right person, the whole probable cause might unravel.
The 911 caller just indicates there's a group of juveniles, there's three black males, two Hispanic, one white, and one of them indicated to me that he had a gun, one of the black males. But at that time, they didn't have a description, a decisive description to indicate it was one of those males.
Like in this case, if he was Hispanic,
Yes.
there'd be no probable cause. If he was white, there'd be no probable cause, right? Because we know that when the officer goes to investigate, it could not have been that person. But when he's going to do his investigation, he's knows one of the black males has a gun, but he doesn't know who. So he has to do the investigation. But for him being able to do it, they all take off.
If I may, Judge. So my argument is just based off of the OR. My understanding is that they're going outside of the OR. They could supplement this case if they want to. They could refile it.
I really want to know what the officer, all I want to know is what the officer knew about who had the gun when he went up there. Did he know anything?
This is legal gold. The judge bluntly asks, what did the officer actually know at the time? This one question can sink or save the case. In criminal law, hindsight doesn't count. Probable cause must exist in the moment of arrest. After hours of review, the judge isn't buying assumptions.
That was
They want facts
after
in.
the
They're not
people had
getting
already
them.
run. The only thing the officers knew was what they had in the first 911 call was that a black male identified said that he did it, but there was three of them and two Hispanics and a white male, and they all ran. So they had PC to at least stop the
What did the 911 callers say as far as who had it?
They just said, Morgan, can you clarify
Can we
exactly
play
what
it?
they said?
The 911 caller didn't give an exact description. He said, and I will say, it kind of agrees that English may not be his first language. When he's speaking to the person on 911, he says that there was a group of juveniles that came into the store, one of them had a gun. He asked if he was licensed. The individual said no, and he asked them to leave, and then he called the police. And he said it's a group of 4 men.
This is the actual
This is the actual 911.
attendant. No, but the gas station attendant.
Yes.
The person working it.
Yes.
And he doesn't give a description at that time.
He doesn't. The 911 operator does not ask.
Pay attention. The key description that may have helped officers only arrived after the suspects had run. That means the officer made decisions based on little to no real-time info. The judge is not impressed, and in court that matters. Think about this: if you got stopped based on vague info after the fact, how would you fight it?
Entertain it and do it again. But
The only thing I can show you is what's in the OR, where it says the description of the black male wearing a black shirt and two-tone colored jeans.
And to be clear, Judge, we will be contacting the officer again today and having them file a supplement to correct.
you're telling me that when the officer rolled up to all those people out there, he knew the person that had the gun was wearing a black shirt and two-tone colored jeans? Is that what you're saying?
I don't know what the officer knew, Judge.
Because if that's the case, if he knows, if he's going up to the group of kids and knows that the gun holder was wearing that, and he's not wearing that, then we know it's no probable cause.
All I'm stating is what's in the OR. I don't have the answers that you're asking for. He's getting the answers based on a phone call that I don't have access to. I don't have.
Yeah, well, that's not, I'm not considering that. I don't care about
Okay,
that.
so then
I don't care what he's telling me. All I care about at this point is what the officer knew when he goes up to do his initial investigation.
Okay, and Judge, just to be absolutely clear, page 7 indicates specifically who told the officer.
Let's break this down. Everyone runs, but not everyone gets charged the same. The guy with the actual gun, he gets charged with possession. The guy who ran, he gets evading. But not everyone who ran got the same treatment. Selective enforcement. Maybe the defense subtly points that out, and the judge raises an eyebrow. Do you think this was fair? Comment below.
Did they all bolt?
Yes, they did.
All of them do. Did they all get charged with the?
I don't know if they caught anybody else. I'm telling Judge, and the reason
They
why I
didn't
brought up
catch
his
him.
criminal history is because I'm telling you, he's known in the community.
Right.
He's
How they
known.
got to him?
Yeah.
If they all
They know.
bolted, why didn't the guy with the gun get charged with evading as well? If
Because
all
they
bolted.
got the felony charge. That's why. They could have been it would have been a dick move and charge him with the one. Again, they could have, but he's lucky they didn't. You know, that's like you get a DWI and then they give you a speeding ticket on top of it, right? That's just
Make the
insult to
argument, Judge.
injury.
I just make the argument.
I'm sorry. You know, but had it been different, I have no problems finding probable cause in cases. You know, it come up after about an hour of argument
Yeah.
here.
And maybe it goes a different way once we actually get the
If
911.
you find anything else, I'm happy.
Here's where the judge shows integrity. Find me more, and I'll reopen the probable cause. That's how justice should work. This isn't about ego, it's about truth. And the judge is making it clear. If there's a new detail, they're open to change. It's refreshing, and it's rare. Props to the bench here.
When you hang with dogs, you get fleas.
No,
You now know.
I know now.
Just listen. You are on bond for 2 very serious felony cases, right? Is it just 2 or is it like 3?
He's got 3 other cases, Judge. I'm just representing.
No. You shouldn't be hanging out with dogs because you could get in a lot of trouble. Even standing there. Life is more difficult for you because of who you are, and you need to be aware of this. You already are.
This moment hits deep. The judge says what many think but few say out loud. Life is more difficult for you because of who you are. That's not legal jargon, that's real talk. Whether it's profiling or systemic bias, it's undeniable that some defendants face uphill battles before the trial even starts. It's a sobering reminder that justice isn't blind, it's trying to be, but the world keeps peeking.
She wants to see me with no gun, sir.
All right. Did you follow?
I can follow that now, Judge.
Please, just no weapons.
Sure.
And then after that, we'll just reset it. Stay in touch with him. I've given you a lawyer. If you don't stay in touch with Ricardo and he tells me he can't get a hold of you, likewise. Okay?
Yes, sir.
Okay,
I
man.
appreciate for giving me the chance, sir.
Be careful.